Imagine for a second that you are behind the wheel. It's December 2007. You're in rural Nebraska, deep in the countryside. It is 9:00 p.m., absolutely pitch black outside, and there's a light snow falling. You know that kind of snow, just enough to blur the edges of the road and mess with your depth perception?
It's that hypnotic kind of driving,
Yeah.
high stress, but also, low visibility.
Exactly. Now, put yourself in the shoes of Justin Pohl. He's not from around here. He's from Michigan, visiting friends. He thinks he's cruising down a straight shot called Road 719. But he's made a mistake.
A big one.
A huge one. He missed a turn, and he is actually on Drive 719. It's a gravel road. And what he doesn't know, because he can't see it yet, is that 1 mile ahead, this road doesn't just curve gently. It terminates in a hard, violent 90-degree turn.
And knowing the facts of this case, he isn't exactly crawling along, is he?
No, he's moving. He's doing 63 miles per hour. The posted speed limit is 50. Suddenly, a yellow sign flashes in his headlights. He slams on the brakes, tires locking up on the gravel, but it is simply too late.
Way too late.
His car flies off the embankment, launches into the air, and rolls over into a culvert. He wakes up upside down, pinned in the wreckage, unable to feel his legs. Severe spinal compression. Frostbite setting in. I mean, it is a literal nightmare.
It is a tragedy, absolutely. But for the purpose of our deep dive today, it is also the foundation of a fascinating legal battle.
Right. Because Justin Pohl survives, and he sues the county of Furnas. He basically says, your road sign was garbage. It was invisible. You didn't warn me in time.
And the county fires back with, you're doing 63 on a gravel road in the snow at night. This is your fault.
And that standoff brings us to our mission for this deep dive. We are looking at Pohl v. County of Furnas, a 2012 decision from the 8th Circuit Court of Appeals.
Right.
But we aren't just recounting a crash. We are going to perform a rigorous dissection of negligence, proximate cause, and the really tricky mathematics of comparative fault.
I love it when we get into the math.
So lay out the path for us. How are we tackling this beast?
We have three massive doctrinal pillars to examine. First, breach of duty. We have to figure out if the county actually messed up legally, and that involves a specific set of federal standards called the Manual on Uniform Traffic Control Devices.
MUTC.
That's the one.
Yeah.
Second, proximate cause. Specifically, does the fact that the plaintiff was speeding break the chain of causation? This is where we get into the concept of efficient intervening causes.
Okay.
And third, comparative negligence. The court found that both sides messed up. So how do we mathematically split the bill?
Okay, let's unpack this. We start with the concept of negligence. In a case like this, how do we even determine if a county breached its duty regarding a simple road sign? I mean, to a layperson, a sign is a sign. It's yellow, it has an arrow. How complicated can it be?
You would be surprised.
Yeah.
Legally, you can't just eyeball it. The general rule for negligence requires four things: dewey, breach, causation, and damages.
The big four.
We know the Canyon County has a duty to keep roads safe. The hard part is breach. And in this context, we don't just guess if the sign was good enough. The specific rule for breach here is measured against those federal standards I mentioned, the manual.
Right.
If the sign doesn't meet the manual's engineering specs, that is strong evidence of breach.
And reading through the case, there's one technical term that keeps popping up. It sounds like something from Star Trek.
Retroreflectivity.
That's the one. What does that actually mean in plain English?
It sounds sci-fi, but it's crucial for night driving. Think about a mirror. If you shine a flashlight at a mirror at an angle, the light bounces off the other way. You don't see it come back to you.
Okay.
Retroreflectivity is a property of a surface, specifically the microscopic glass beads in the paint, that grabs the light and shoots it directly back to the source.
So if my headlights hit the sign shoots the light right back into my eyes.
Exactly. If a sign is retroreflective, it glows in the dark. If it isn't, the light just scatters and the sign just looks like a dull, dark square. You literally might not see it until you are 10 feet away.
Which is terrifying. Okay, let's apply this to the nightmare on Drive 719. First, what are the legally dispositive facts regarding the sign?
The sign in question was a standard W16, a 2-foot by 2-foot yellow diamond with a black 90-degree arrow. Crucially, the county had placed it exactly 110 feet before the start of the curve. At trial, the plaintiff brought in a traffic engineer named Ronald Henson. Henson actually went out there and examined the sign. He testified that the sign face was heavily scratched, abraded, and essentially lacked that retroreflective capability we just discussed.
So it was dead.
It was dead. He took flash photos at night, and in the photos, the sign is basically a ghost, barely visible compared to a properly maintained sign in the distance.
And what was the core legal issue regarding the sign?
The issue was whether the county breached its duty of care by failing to maintain the sign's retroreflectivity and by placing it only 110 feet from the curve. Essentially, the question is, was the sign legally invisible, and was it positioned too close to the danger zone to be useful?
Okay, so what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule comes directly from the Manual on Uniform Traffic Control Devices.
Yep.
It dictates the standard of care. It has two distinct elements for this situation.
Okay.
Element 1 is retroreflectivity. A sign must possess surface properties that return a large portion of light directly back to a point near its origin.
And the second?
Element 2 is placement and legibility. Warning signs must be placed roughly 100 feet before a curve, but, and this is the critical caveat, this placement table assumes the sign is legible from 250 feet away.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, retroreflectivity?
Well, the sub-rule here is straightforward. Warning signs have to reflect light to be visible at night. If they don't reflect, they aren't warning signs. They're just metal squares on a stick.
Right.
For the application, the court relied heavily on expert Henson's testimony in those photos. Henson noted the sign was faded and scratched, but the flash photos were the smoking gun. They showed that this specific sign was barely visible in the dark. It failed to return that large portion of light back to the driver.
So,
The court's conclusion was clear. The sign failed the retroreflectivity standard. For all intents and purposes, it was dead.
understood. Now, what about the second element, placement and legibility?
This is where the analysis gets really interesting, because it connects physics to the law. The sub-rule states that the placement tables in the manual, which allowed for a 100-foot distance, are valid only if the driver can read the sign from 250 feet away.
And why is that?
The logic is perception reaction time. You need to see the sign, process a curve, take your foot off the gas, and hit the brake. That takes time and distance. In applying this, the court found that because the sign wasn't reflective, it was not legible at 250 feet. It wasn't even legible at 300 feet. It was only visible when the driver was right on top of it. Therefore, placing it only 110 feet away gave the driver insufficient reaction time.
So the placement was negligent because the sign was bad.
Precisely. You cannot put a hard-to-read sign that close to a cliff edge.
And after analyzing all the elements, what was the court's final conclusion on breach?
The district court's finding of negligence was not clearly erroneous. The county breached its duty. They failed on the quality of the paint, which triggered a failure on the positioning of the post.
Okay, so the Casa County is definitely on the hook for having a bad sign. They can't wiggle out of that. But they didn't just roll over and pay up. They launched a counterattack.
Right. This is the classic defense maneuver. They essentially said, okay, our sign was bad, but look at the driver. He was doing 63 and a 50 on a snowy gravel road. Even if we had a neon billboard out there, he would have crashed.
This brings us to the second pillar, proximate cause. The Aga County is arguing that Pohl's speeding was the real cause, not the sign.
Exactly. The general rule for proximate cause in Nebraska has three parts. First, but for, causation. Did the negligence actually cause the event? Second, the injury must be a natural and probable result. And third, there must be no efficient intervening cause.
Efficient intervening cause. That is a mouthful of legalese. Before we apply it to Pohl, I want to make sure I really get this. Can you give me a visceral hypothetical? What breaks the chain and what doesn't?
Sure. Think of it as a chain of events test. Let's use a pothole scenario.
Okay.
Scenario A. The county leaves a giant dangerous pothole in the middle of Main Street. A driver hits it while speeding 10 miles per hour over the limit. The car is wrecked. Is the speeding an intervening cause?
I'm going to say no.
No. Why? Because people speed.
Incorrect.
It is foreseeable. Traffic engineers know this. They design for it. The speeding driver might be partly at fault, but the chain of liability back to the county for the pothole remains intact.
Okay, scenario B.
Same pothole. But this time, as the car approaches, a prankster pushes a giant boulder off an overpass, crushing the car right as it hits the pothole. Or maybe the driver is driving blindfolded on a dare.
That's not foreseeable.
Not at all. That boulder or that blindfold is an efficient intervening cause. It snaps the chain. It absolves the culinary because they couldn't possibly plan for a boulder attack.
That makes perfect sense. So the test is really about foreseeability. If the county should have seen it coming, they are still on the hook.
Precisely. If it's a normal bad behavior, it's foreseeable. If it's a bizarre bad behavior, it's an intervening cause.
So let's return to Pohl. The county is saying his speeding was the boulder. It was so reckless it broke the chain. First, what are the legally dispositive facts regarding causation?
The facts are that Pohl was driving 63 miles per hour in a 50 zone. The road was gravel and it was snowing. Pohl testified that he doesn't remember seeing the sign at all, which makes sense given our discussion on retroreflectivity. The county argues two things. One, he might have ignored a good sign anyway because he was zoning out. And two, his speeding was so reckless that it constitutes that efficient intervening cause we just talked about.
And what was the core legal issue?
Was Pohl's speeding an efficient intervening cause that severed the causal link between the county's bad sign and the crash? In other words, was doing 13 over the limit unforeseeable?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule focuses on the connection between the negligence and the injury. Element 1 is but for causation. The plaintiff has to prove that the injury wouldn't have happened without the defendant's negligence.
And element 2.
Element 2 is intervening cause. As we discussed, a third party's act, or the plaintiff's own act, only breaks liability if it is new, independent, and unforeseeable.
Thank you. Now for the court's elemental analysis. How did the court apply the first element, but for causation?
Well, the county tried to argue that because Pohl missed the curve, he would have missed it regardless of the sign. The court didn't buy it. They applied the but-for test by looking at the purpose of the sign. They found that if the sign had been reflective and placed further back, say 200 feet back, it would have caught Pohl's attention earlier. Even if he saw the curve at the last second, a bright warning sign seconds earlier would have prompted braking.
So a better sign changes the outcome.
It changes the timeline of the crash.
Yeah.
So the conclusion for this element was that the but-for test was met.
Understood. Now what about the second element, intervening cause and foreseeability? This is where the speeding as a boulder argument lives.
This is the critical juncture. The sub-rule is that tortfeasors, the county, are liable unless the intervening act is truly extraordinary.
Right.
In applying this, the court looked at testimony from traffic engineers. And this is fascinating. The engineers admitted under oath that they design roads assuming drivers will exceed the limit. Yeah. They essentially build in a fudge factor for speeders doing 10 to 15 miles per hour over. Pohl was doing 13 over. He was right in that foreseeable deviation pocket.
So he was a predictable problem.
He was a predictable problem. Therefore, the conclusion was that speeding was foreseeable. It is not an efficient intervening cause. It didn't look like the boulder off the cliff. It looked like a typical driver in a hurry. The crunny remains on the hook.
I love that fudge factor detail. It basically means the county knows we speed and they have to put up signs that account for it, so the county is liable. But here's where it gets really interesting. Justin Pohl won the case, but he didn't walk away with the full amount of damages.
No, he did not. And this brings us to the most nuanced part of the case.
Comparative negligence. How do we split the blame?
The general rule is governed by a Nebraska statute. Nebraska is what we call a modified comparative negligence jurisdiction.
Meaning?
Here's how it works. If the plaintiff's negligence is equal to or greater than the defendant's, so 50% or more, they get nothing. Zero. If it is less than 50%, they win, but their damages are reduced by their percentage of fault.
So 49% fault means you get paid. 50% fault means you go home empty-handed. That is a brutal cutoff.
It is the razor's edge of civil litigation.
Okay, let's analyze the apportionment in Pohl. First, what are the legally dispositive facts?
The trial court did the math and assigned 60% fault to the county and 40% to Pohl. The total damages for his medical bills, pain, and suffering were calculated at roughly $678,000. But because of that 40% fault finding, the actual check written to Pohl was reduced by 40%. Pohl appealed this specific math. He argued that his speeding didn't cause the accident. He claimed he would have crashed anyway, even at 50 miles per hour, because the curve was so sharp and the road was ice and gravel.
So he argued he shouldn't be 40% liable for the crash.
Right. He's saying, I would have wrecked regardless, so don't blame me for the wreck.
And what was the core legal issue?
The issue is, can a plaintiff be found 40% negligent for speeding if the speeding contributed to the severity of the injuries, even if it didn't cause the crash itself?
That's a fine distinction. So, what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule hinges on the definition of proximate cause in relation to damages, not just the event. Element 1 is proximate cause of injury. Negligence is actionable if it causes the injury or enhances the injury, not just the accident event.
Okay. And element 2.
Element 2 is the standard of review. Apportionment is a question for the fact finder, the judge or jury, and an appellate court will only overturn it for clear error.
Thank you. Now for the court's elemental analysis, this is the part I want to dig into, the physics of it. How did the court apply the first element, proximate cause of injury?
This relied heavily on the black box data from the car and the expert witness, Trooper Vandenberg. This is where the distinction between causing the crash and causing the injury becomes crystal clear.
How so?
The application was purely kinetic energy. Vandenberg testified that if Pohl had been going 50 miles per hour, the legal limit, he still would have left the road. He still would have crashed. However, the physics would have been different. He would have left the road at only 15 miles per hour. The car likely would have stopped in the grass before hitting the culvert. It would have been a minor bump, maybe a towed car, but no ambulance.
But he was going faster.
Right. Because he was doing 63 miles per hour, he left the road at 48 miles per hour. That extra energy caused the rollover and the severe spinal compression.
So the conclusion?
The conclusion. Speeding didn't cause the crash, but it proximately caused the catastrophic injuries. And in a personal injury lawsuit, you are suing for the injury. Therefore, the negligence sticks.
That is a crucial distinction. He bought the broken back with those extra 13 miles per hour. Understood. Now, what about the second element, review of apportionment?
The court looked at the 60-40 split. They found it bore a reasonable relationship to the evidence. The Kekatiani created the trap. That's the 60%. But Pohl's speed turned a minor fender bender into a life-altering event. That's the 40%. Since the judge's math wasn't clearly wrong, the appellate court has to let it stand.
And after analyzing all the elements, what was the court's final conclusion?
The Eighth Circuit affirmed the district court in full. Judgment for Pohl reduced by 40%. He walked away with about $407,000.
Which, let's be honest, is a lot better than zero, but it's a painful drop from nearly $700,000. It really shows how expensive speeding can be, even if it's not the primary cause of the accident.
Precisely. It's a harsh lesson in physics and law.
So we've dissected the sign, the speed, and the split. If you had to distill this down for our listener, the learner, what is the ultimate toolkit here? What should they take away for their next exam or legal battle?
Okay, if you are looking at a negligence problem involving infrastructure, use this diagnostic framework. Number 1, check for statutory or manual compliance. In any case involving roads or signs, do not just argue reasonable care. That's too vague. Look for the governing manual, like the MUTCD. Non-compliance, like the lack of retroreflectivity here, is your smoking gun for breach.
If the book says it should glow and it doesn't, you win.
You win on breach. Number 2, analyze the intervening cause. When the defendant points the finger at the plaintiff, ask yourself, was this bad act foreseeable? Speeding a little bit, foreseeable. Pushing a boulder, unforeseeable. If it's foreseeable, the chain of liability holds.
Got it. Number 3.
Distinguish accident versus injury. This is the nuance that costs the plaintiff money. In comparative negligence, a plaintiff's fault counts even if it only worsened the result. You can be liable for the extent of your own broken bones, even if someone else caused the crash.
And finally,
Number 4, math matters. Never forget the 50% bar rule in states like Nebraska. If the plaintiff is 50% or more at fault, they get 0. As a lawyer, your primary battle is often just keeping that percentage at 49 or below.
that is a powerful framework. It really clarifies how these cases are won and lost.
It's the difference between a payout and a dismissal.
Before we close, here is a thought that keeps nagging at me. We talked about that 50% cliff. Pohl was doing 13 miles per hour over the limit. The experts said 10 to 15 over is foreseeable.
Right. He was just inside that safety zone.
What if he was doing 20 over or 25? At what point does the speedometer tip the scale from foreseeable speeder to reckless maniac?
That is the million-dollar question. And in this case, it literally might have been a million-dollar question.
Because if he's doing 20 over, maybe that 40% fault creeps up to 51%. And if it hits 51%, that $400,000 check vanishes. It becomes 0.
It absolutely does. The line between a life-changing settlement and walking away with nothing but medical bills can be measured in just a few miles per hour on a gravel raid. If he had been going slightly faster, the court might have said, okay, now you are 51% at fault for your own injuries. and the Kaijo pays nothing.
A terrifying thought to end on. It gives drive safe a whole new meaning. Thanks for guiding us through the maze.
Always a pleasure.
That's it for this deep dive. Check your signs, watch your speed, and we'll see you on the next one.